All right, once again, thanks everybody for joining us. Again, the webinar today is on conservation easements presented by Allison Elder, Vice President and General Counsel of the Texas Agricultural Land Trust. The webinar today is made possible through funding provided by the San Antonio Livestock Exposition Incorporated, and it's hosted by the Texas Wildlife Association and Texas A&M AgriLife Extension. With that, I will pass the controls over to you, Allison.
Thank you, Clint.
Yes, ma'am.
Good afternoon to everyone. My name is Allison Elder, and I am an attorney in San Antonio, Texas, working on behalf of the Texas Agricultural Land Trust. I have been working with conservation easements for 15 years, about half of that time on the nonprofit side, which is the holder of an easement, and half the time representing private landowners who are the donors of conservation easements. So I hope to give you a good overview of this tool today and look forward to hopefully answering all of your questions and getting you up to speed. I think we had some questions we were going to ask here. Can we do that? Great. It always helps me in presenting to know a little bit more about the audience. So I'd like to ask you to look over two poll questions. Here's the first, and give me some sense of your familiarity with conservation easements. And I'll give you about a minute to answer. Okay, Clint, can we close the poll? And the second question we've designed is geared to helping me understand the audience today. So let's take a look at that poll question.
And wait just 1 second, Allison, while it collects the responses.
Okay, so this question is geared toward your background. If you're a landowner, an advisor to a landowner, an agency employee, or something else. Okay, let's close the poll. Thank you all. That will help me in the presentation, and I'll get started now. A conservation easement is a voluntary legal agreement between a landowner and a conservation organization or government agency that permanently limits a property's use in order to protect the property's conservation value. And I underline voluntary here because this is not an agreement or a legal interest that can be created through condemnation. It always involves two willing parties, the holder of the easement and the donor of the easement. The conservation easement is a real property interest, so it's filed at the courthouse and it runs with the land. Like many other easements in Texas, it becomes part of the title to the property. As part of the title of the land in the future can be sold on the open market to a third party. It can be gifted to a family member or any beneficiary. And the conservation easement is binding on all future owners. It's a static agreement. It should not really change over time. And those terms that are created at its inception apply to all the future owners. So if you've studied property law at all, you may know the analogy of a bundle of sticks, and we often think of owning property as being a bundle of sticks like you see in this picture. And a landowner can selectively remove certain rights from the title of the land. very little is actually mandatory or required for a conservation easement, and I'll tell you more about that. Really, each easement is individually tailored to the vision of the landowner and the conservation values, the natural attributes of the property. So what is a conservation easement? It's important to know that a conservation easement is provided for in state law. In Texas, the enabling statute is the Natural Resource Code. The concept of a conservation easement where you have a non-possessory interest in land is not one which is supported or in keeping with our English common law. So you wouldn't have this interest arise without statutory authority. And all the states in the country, except for one, North Dakota, have passed enabling statutes, which allows landowners in their state to choose to create a conservation easement. Now, conservation easements are often classified in different types. The version that we work with the most here in the state of Texas is a donated easement. It's governed by the IRS regulations because there are some charitable deductions which can be engendered for a qualified conservation easement. And in order to qualify, the conservation easement has to be perpetual. It can't be for a term of years. However, I do want to mention that Texas law does allow for a conservation easement which is for a period of years. It's not required by state law, but it is required in order to qualify for a deduction under the federal IRS rules. But also we're seeing increasingly in Texas purchase easements, which are also known as a purchase of development rights. And we have a new federal program, the Purchase of Agricultural Conservation Easement, or PACE. But purchase conservation easements are starting to move forward, and they're designed toward protecting a particular resource that's of concern to usually a governmental agency, and the governmental agency decides they're willing to pay landowners in exchange for the agreement not to develop their property. And then the third type that I have listed here is a bargain sale, which is a combination of a donation and a purchase easement. It's often found where somebody is selling a conservation easement for less than it's appraised for, so they're getting some cash at closing, but they're also getting some charitable deductibility and benefits that way, assuming it qualifies. Let me tell you about the different purposes of a conservation easement, because this is a very key term. Conservation easements have different purposes, including the protection of significant natural resources, water, endangered species, their habitats, protection of historical resources, providing public access, and recreation and education. These are stemming from the federal laws that say what type of property would qualify for a deduction. You need to have certain type of attributes on the property which fall into one of these categories and enable the deduction to qualify. But we also have a broad category called open space, which is the category I'm working in, which is agriculture. The purpose of an agricultural conservation easement is to protect the viability and productivity of agricultural land while also protecting other conservation values like wildlife habitat, water quality, and scenic landscapes. So an agricultural conservation easement will limit the future non-ag use of the land, like industrial uses, quarrying, strip mining, subdivision. It will encourage the business of farming and ranching, but it won't require it. It's flexible in that it allows the rancher farm to adapt to changing economic conditions and agricultural practices. It permits constructions of new buildings which are compatible with agriculture. It doesn't require public access, and that's true for all conservation easements. The landowner retains the private ownership of the ranch or farm subject to the easement restrictions, and it will allow for some oil and gas activity as long as there is minimal permanent damage to the surface. Now, this list is specific to an agricultural conservation easement, but most of the other easements we work with in Texas are wildlife habitat easements, and the analysis would be the same. It would limit future non-wildlife habitat use of the land. It would encourage the promotion and preservation of wildlife habitat. It would allow for some flexibility for the landowner, but the primary purpose of all the restrictions would be geared toward keeping the property in good condition to be providing habitat for native species. Oil and gas production is something that we're dealing with on an increasing level as we're seeing new methods of production in the state. And so I want to give you a little bit of information about this. Subsurface extraction is allowed under a conservation easement if there is minimal permanent damage to the surface. And the way that we do this is through a variety of mechanisms, but we're customarily trying to make sure that we're following the Internal Revenue Code requirements. Some of these requirements are spelled out in the tax code in the Treasury regulations, and some of them are further defined by case law over time. But we do have some guidance that oil and gas production is allowed if it's limited and localized. There was a document produced by the IRS called the private letter ruling, which says limited and localized is that for surface use destruction of 2.6% of the property. So that's a standard we often see in conservation easements, something less than 2% of the surface use of the property. Also, restoration is required after production, and oil and gas production may involve surface use agreements. Here at the Texas Agricultural Land Trust, we customarily will require a preemptive surface use agreement if the landowner does not own all of the mineral interests, to ensure that any future oil and gas activity will conform to a surface use agreement at least as restrictive as the one that's provided as a template for that. Now, for other minerals, it's important to know that the IRS code does require that surface mining is prohibited. And typically in Texas, the surface owner will be able to control production on the surface. So that's something we're able to work out with the landowner directly through the conservation easement. Many land trusts use special techniques to deal with borrow pits. If you have property that you're using caliche and gravel from time to time, these may be cut out of the deductible conservation easement and a non-deductible conservation easement placed on those areas so that the conservation easement, which is submitted to the Internal Revenue Service for consideration as a deduction, will say that surface mining is prohibited. And then there's a second, very small conservation easement, which is not submitted for a deduction, which allows some surface mining, but prohibits other things that the land trust would not want to see on that property, like a strip mall or a subdivision. So I'd like to give you an introduction to the process of creating a conservation easement. And again, this is geared toward an agricultural conservation easement, but the process is really the same for any conservation easement, as well as purchased and donated. The first is a discussion with the landowner about reserved rights. And some of the most fundamental terms are how many partitions would be allowed of the property in the future and how many building envelopes. A building envelope is an area which is customarily defined at the beginning of the process. a specific geographic area where there may be structures in place now or the ability to create structures in the future, and the landowner retains the right to use those structures, build gardens, tear down those structures and replace them with different structures, add new structures. It's an area of heightened building allowance in a conservation easement. And it enables the land trust to make sure that the landowner's needs will be met with the building envelope without having those structures constructed in a part of the property that is particularly sensitive and not as desirable from a conservation standpoint for future structure. So those specific terms are worked out between the landowner and the land trust. Then the landowner will customarily hire an appraiser who will produce an appraisal for them. And I'll give you more information about the valuation. But the reason that that's important is that the appraisal is required to substantiate the value of the gift, which is the conservation easement. And I noted here for you that it's very important that you get an appraiser who is experienced. There are a lot of potential slip-ups in the requirements for appraising conservation easements. There are courses which are given that bring appraisers up to speed on the requirements, and it's really in the landowner's best interest to work with a knowledgeable advisor here in this area. Another process which happens during the development is the development of a baseline report. This report provides two functions. The first is it documents the condition of the property at the time of the transaction. So future monitoring visits will assess changes over time in comparison to the baseline report. But it also helps the drafters of the conservation easement to identify the values of the property which will qualify for the tax deduction. You see, every conservation easement and every land trust has a requirement to be protecting some of the attributes which have been considered by the federal government to provide public good, like water quality protection, scenic views, working lands with prime farmland soil. So we have to have a determination that those attributes are present on the property in order to make sure that we're fulfilling our public mission. So let me give you some more information about the valuation of conservation easement. The customary way to value a conservation easement is essentially to value the property two times. The first time, the property is valued before the conservation easement. So it's a traditional and typical conservation property evaluation, and that the appraiser is determining if you put the property on the market today with no restrictions on the title, what would a willing buyer and a willing seller meet at for a price with neither being under any compulsion to buy? That's the standard they'll customarily use for any appraisal. But then he does a second appraisal, which is what would this property fetch on the open market after this restriction is placed on the title? The change in that value is the value of the charitable contribution. And I've used some numbers here which are in keeping with an average valuation that I would see in Texas. So you can see that the conservation easement is representing 35% of the unencumbered title to the property. I have a note here for you, and this is an example of one of the trip-ups, that if you've recently purchased property, there's going to be a presumption that the before value of the property is going to be what you paid for the property. The IRS is not going to let you buy property for $2 million and then say that it was worth $4 million when you bought it. So we've talked a little bit about the length of a conservation easement, but these are some of the questions that will always come up when you're presenting on this topic. And just to recap, in Texas, it is permissible to do a conservation easement for a term of years. I will tell you from my experience, most land trusts do not want to hold a conservation easement which only lasts for 10 or 20 years because it's a lot of work to create a conservation easement, and they want to work on projects which will ensure a perpetual protection. But it is permissible legally, and it can be done. Sometimes landowners will have an opportunity to do that under a purchase program where they'll purchase a conservation easement just for a period of years. Condemnation is an important consideration, and a customary conservation easement which is held by a nonprofit organization will not preclude condemnation from happening. So if you donate a conservation easement to a nonprofit land trust and a power line or pipeline company comes along the next year and wants to condemn a part of your property to put a power line through it, the conservation easement will not legally prevent them from doing that. Now, there are many circumstances in Texas and examples where a pipeline or power line company has come across a property where a conservation easement has been placed and they've been dissuaded from going through that property because of the nonprofit interest and the potential public interest that I alluded to earlier. Now, the situation can be a little different if you have a conservation easement with a government entity, because the government entities can trump one another. So the highest example in this scenario would be a conservation easement which is held by a federal entity like the NRCS or the U.S. Fish and Wildlife Service or the Corps of Engineers. In those circumstances, as a federal interest in land, most condemners would not be able to trump that federal interest, and you would be in a better position to dissuade or preclude a legal condemnation of the property. I'm often also asked about termination, so I want to let you know that a conservation easement should be entered into as a perpetual agreement. There are provisions for termination. A conservation easement can be terminated if the purpose of the gift could no longer be accomplished. So if you go back to my example about the different types of purposes, an example that maybe you're providing habitat for a special species. If that was your only purpose in the easement, and if that species ceased to exist, then that could potentially be grounds for termination. But customarily in a conservation easement, there are multiple purposes listed. I mentioned at the beginning that for our easements, our agricultural easements, agriculture is our primary purpose, but if there are public scenic values or wildlife habitat values or water values that are cited and relevant, then we do include those. And so even if one of your purposes fell to the wayside and was no longer possible to accomplish, customarily there would be other purposes which would protect that interest. Now, if a conservation easement is terminated, we expect in Texas, though we don't have case law on this, that it would take a court proceeding, that customarily a court would have to play a role in terminating that interest. Do we have any questions at this time, Linda? I'm still seeing the poll up. Okay, I'm going to go on. Let me tell you about the tax incentives for donated conservation easements. Now, I went back and forth on how to present this information to you because the law has recently changed, and I decided to be an optimist and present you with a more optimistic scenario. So from 2006 until 2013, Congress, I believe 4 times, passed extensions of accelerated deductibility for conservation easements. And under that tax treatment, a conservation easement is deductible up to 50% of your adjusted gross income. And you can carry forward that deduction in addition to the year of the donation up to 15 years. So let me give you a specific number example about how this would work. And you can read through this with me. The landowner's annual adjusted gross income is $234,000 a year. We have to make an assumption about how their income will change over the years, so I'm going to assume it's constant. The deduction for his conservation easement in the first year is $117,000. He's able to carry that forward every single year for the next 15 years. So the total value of his deduction is $3.7 million. Now that's assuming that he donated a conservation easement that was valued that much, which is pretty high, but it's certainly possible and happens fairly frequently. Now, I have my note here for you because this, unfortunately, is not the treatment today. The treatment today at the beginning of 2014 for the deduction of a conservation easement is back to its standard treatment with a deduction of up to 30% of your adjusted gross income and a 5-year carry forward. So if you look at this example, you can see that the 117 is going to be reduced quite a bit, and the carry forward will only be for 5 additional years. So unless a landowner has a really large adjusted gross income, he's not able to capitalize on as much of the deduction under the customary treatment. Another part of the incentive, which is important to tell you, is that for qualified farmers and ranchers, and those are people who make more than 50% of their adjusted gross income from farming and ranching activities, they can deduct up to 100% of their adjusted gross income. Now, a really important part of conservation easements and the tax incentives is not the deduction from income tax, but it is the estate tax. We are seeing in Texas that concerns about estate tax are one of the largest motivations for selling property. And take a look at that blue line there. You'll see that pretty much for the entire period that this has been tracked by the Texas A&M Real Estate Center, it has been the top motivation for subdividing property. And I'm going to give you a little example here of 2 farms and how a conservation easement can help a family deal with estate tax considerations. So I have here a Jones Ranch and a Smith Ranch. You can think of them as 2 neighbors with 2 pieces of property equally valuable next to each other, both worth $17 million on the open market, completely unrestricted. The Smith family decides to put a conservation easement on their property, and it decreases the value of their property to $9 million. When Farmer Jones dies, he has not put a conservation easement on his property. So in order to pay his federal estate tax, he has to have some sales to pay his taxes. And there's a supplementary division for his heirs. I'm assuming he has 4 kids, so I've drawn for you a piece here that is, let me see if I can mark this. A piece here that's going to a sale to pay the taxes, another piece that's going to sell the taxes, and then 4 pieces for each of his children. Now, if you're working in the agricultural industry, you know that you get to a point where it's just the property is too small, too fragmented to sustain agriculture. And this is really what motivates us at the Texas Agricultural Land Trust to try and prevent that from happening. So in this scenario, in contrast with the Smith Ranch, his family goes ahead and they use an entity. They put the property into a family limited partnership or a trust or an LLC, and then all the heirs are going to take title to this property, subject to a conservation easement so it cannot be subdivided, and also as undivided interest holders so that they're managing the family property together. Now, we do have opportunities from time to time to purchase agricultural conservation easements from a federal program, and I'm sure everyone has been made aware of the Farm Bill, which recently passed. So in the past, you may have heard of some NRCS programs which pay landowners for conservation easements, which were the Grasslands Reserve Program and the Farm and Ranch Protection Program. Those were the most active in Texas. Those programs are being merged into the Agricultural Conservation Easement Program, and we are still reading up on this and learning more about it. But I do want you to know that federal dollars will continue, and one of the barriers to doing conservation easements in Texas has been the requirement of a local match for money in Texas. And the new program does not require a local match, so we should have more flexibility in Texas to participate here. Now, also, I want to tell you that we have a state program to purchase agricultural conservation easements. And I mentioned at the beginning of the presentation the Natural Resource Code, Section 183, and this is where you could read about the Texas Farm and Ranch Lands Conservation Program. It was created by the legislature about 6 years ago. It's managed by the General Land Office, and it allows for both perpetual and 30-year term easements. It has an oversight board with representatives from statewide agricultural organizations, but it's not yet funded by the legislature. It has received some funding from some federal programs that have been redirected to the state program, but these funds have not come from the state level. Also, there are a number of local and resource-specific programs which are going on in the state. One of the largest is happening where I live in San Antonio through the City of San Antonio's Aquifer Protection Initiative. This was a sales tax-funded initiative that was passed by the voters in the City of San Antonio 3 times, in 2000, 2005, and 2010. And its specific purpose is to protect the Edwards Aquifer. So for this program, the City of San Antonio has modeled through a GIS program the recharge zone, the contributing zone, fault lines, sinkholes, caves that are known to feed the aquifer. And they're working with 2 nonprofit organizations, the Nature Conservancy and Green Spaces Alliance, to approach landowners who have property that's situated over the recharge zone or the contributing zone, and to offer to pay them appraised value for a conservation easement. And the $90 million figure there is what was allocated in 2010. There was, I believe, $90 million in 2005 and $45 in 2000. So a large amount of money has been invested to protect the drinking source for the City of San Antonio. And they've protected about 20% of the recharge zone, a little over 200,000 acres, mostly in Medina and Uvalde County to the west, because water modeling shows that the water that enters the recharge zone travels eastward. The City of Austin also has a program. It's a bond initiative to protect Barton Springs. And you may be aware of an Army program to create compatible use buffers to protect military installations against encroachment which is not compatible. I'd like to tell you a little bit about the role of the easement holder. The easement holder is often a nonprofit land trust whose mission is land conservation, but Texas law also allows a governmental entity to hold conservation easements. As an example, the city of San Antonio holds their conservation easements that they're purchasing under that program. The easement holder has the right to monitor and enforce the easement, and they typically visit the property once a year to ensure that the terms of the easement are being upheld. Texas has about 26 land trusts, and each have a specific mission. Many are working locally in their communities, and some are working statewide. For us at the Texas Agricultural Land Trust, our mission is to halt the loss and fragmentation of rural agricultural lands in Texas. Our board is comprised of landowners who understand the day-to-day challenges of working land, and we hold agricultural easements on rangeland and wildlife properties all over the state of Texas. And our guiding principles dictate that we don't interfere in day-to-day management of a farm or ranch. So let me give you some of the benefits and drawbacks of conservation easements. The conservation easement is a voluntary mechanism to protect property from fragmentation or development. It fits the family's long-term stewardship goals for the farm or ranch because, remember, it's individually tailored to their needs. The income tax deduction that's created under the federal tax code can be a benefit, and the estate tax benefit can be very significant. It can enable a family to pass on property to the next generation when that wouldn't be possible without subdividing otherwise. And in the case of a purchase conservation easement, it can allow families to convert a piece of property that they never intended to develop anyway into cash. So for some of these families, they're essentially owning the property with development rights in that bundle of sticks that they never intend to exercise or capitalize on. So rather than paying estate taxes on that, it's better for them to remove those rights, to get cash in exchange for those rights, and to pass the property on the way they intend to. But there are drawbacks that are important to consider when you're evaluating a conservation easement. The projects are expensive, and in the case of purchase easements, the cash match that I mentioned earlier is not always available. A conservation easement donation is going to require you to hire an attorney, an appraiser, pay baseline expenses typically. All of this can add up, and the land trust will also ask for a stewardship donation to help them be a long-term steward of the property to pay for their cost of annual monitoring. A conservation easement typically takes a long time to complete, between maybe 3 and 9 months. A conservation easement will not ensure that the land will continue to be farmed in the future or managed for wildlife, only that it'll be open and available for those things. And a sale of a conservation easement is going to engender some tax liability, typically capital gains tax, depending on how long you've held the property. Those income tax benefits are generally only available to the first generation of easement donors. And of course, most importantly, the use of the property is going to be limited forever in the future by the terms of the conservation easement. If you change your mind in the future, the land trust will not have the ability to let you do additional things. Here are some resources for you to learn more about conservation easements. Our website at Texas Agricultural Land Trust, the Texas A&M Land Trend Study, which I understand is being updated, the American Farmland Trust, and it's important that you know about the Texas Land Trust Council, This is an umbrella organization which provides support to land trusts in Texas. They will be having their annual conference next week in Austin, starting with a Wednesday workshop geared specifically for landowners to talk about conservation tools, really besides the conservation easement. If you think you're interested in protecting your property but not ready to take the perpetual plunge of a conservation easement, this program on Wednesday is designed for you, and then Thursday and Friday will be additional programs. So I encourage you to look at their website. And also the Land Trust Alliance. This is the national support organization for the 1,700 land trusts in our country. They have an annual conference, which is in September this year, and their website is an excellent resource. I use it almost on a daily basis. That's the end of my program. Clint, if you can help me see any comments, I'm ready to take questions.
Sounds great. Sorry, I have my other computer on. Thanks for everything, Allison. We have a few questions that came in, and I'll read those off to you. The first one is, if a title is silent about conservation easement, can it be assumed that there is no conservation easement on the land?
Yes, a conservation easement should show up in a title commitment. If you're considering purchasing a piece of property, it would be listed as an exception on the Schedule B. If it's not listed as an exception, then it would not be on the title, or you'd be insured if the title company missed it.
Okay. Are some oil companies shying away from land that is under conservation easement?
Well, I think that oil companies would certainly prefer to deal with a landowner who's willing to sign the Producer 88, the very standard form that allows them to do anything they want to the property for the most part. So I would say that if a oil company was interested in producing on a property that had a conservation easement, they would read the conservation easement, and if the conservation easement addressed surface use, they would recognize that they have some higher hoops to jump over. It doesn't mean that they can't produce oil and gas there. We have active oil and gas on some of our conservation easements at Paul, but it does mean that they would have to probably build their roads in certain areas, maybe not put down their oil pads too close to creeks and rivers. They'd have to restore. They couldn't spread the production water that comes back out of their fracking operations. They couldn't spread it on the soil. So there would be some additional protections for the landowner.
Okay. The next one is going to be a multi-part question. It's two questions, but I'll combine them. First is, what are the main differences between agricultural and wildlife easements? And second, are there size restrictions on wildlife easements?
Okay, so the main difference between agriculture and wildlife easements will be, I would say, primarily the way that you address vegetation. So you know that vegetative cover, is really critical for wildlife habitat. So if you were writing a wildlife easement and wildlife was your primary purpose, you would probably be pretty restrictive about the landowner's ability to modify the vegetation. For an agricultural easement, we want to give the landowner more flexibility to graze and to produce crops if the land is well suited to that. So we are not as restrictive in our easements about what they can and cannot do about their vegetation. But both of those would have many of the same fundamental requirements about, as an example, oil and gas, or subdivision, quarrying, surface mining, really intense grazing over levels which damage the property, changing the topography of the property, too much impervious cover, meaning cement and asphalt roads. Those things would customarily be limited either way. And then to the second question, size restrictions, that's a really interesting question. There's not a minimum size for any type of conservation easement. The smallest one I've done was 5 acres in town in San Antonio. The largest I've seen is 60,000 acres. But for any land trust, you have to evaluate if the size of the property is sufficient enough to support the purpose that you're trying to accomplish. So for us, you know, we're looking more from an agricultural perspective and wanting to make sure that the size of the property is significant enough to support an agricultural operation, so that if the person who owns it in the future chooses to have an agricultural operation, they have the capacity to do that. Now, for wildlife, it would be a similar type of analysis. You would evaluate what type of species are on this property that we want to provide for, and what type of size do they require. And if the property is large enough to support that species, even if all the properties around it become developed in the future, then you would feel comfortable that you were going to engender perpetual protection, which is what we're all trying to do. Okay, I see the questions now. So I see the next one is asking about when a landowner does not own mineral rights, are they required to compensate the mineral right owner under the accommodation doctrine for the requirement? I don't know if I'd say they are required, but it is customary. It's not unusual that if you don't own your mineral rights and you want to do a conservation easement, that you would need to coordinate with the mineral right holder, and they may voluntarily agree to limited and localized protection, or they may want you to pay them to agree to that restriction. And I did not mention this in my presentation, but in making these evaluations, we will very often consult with a geologist, and sometimes we find that there are not commercially viable minerals in the area. So that can be persuasive to a mineral holder that there's not really a lot of economic opportunity there anyway. That's called a geologist remoteness letter. Okay. The land trust treat easements purchased or donated by a government or public entity differently than a private landowner? No. We purchased our first conservation easement this summer. It was through the state program I was telling you about, and we processed it exactly the same way. We monitor it on an annual basis and treat it really exactly the same. Okay, a hypothetical on purchased pieces of property, the financial benefits that the new owner might receive. So I'm trying to think of how this is different than the example I gave going back. Paul, can you chime in on that? So let's see. Take you guys back to this example is a pretty standard. So if a landowner purchased property for $2 million and 4 years later donated a conservation easement, it decreased the value of the property $700,000. So his property is now worth $1.3 million, and he can claim on his taxes that value, that $700,000, in accordance with the 30% AGI and the 5-year carry forward that I mentioned in the presentation. And again, hopefully Congress will expand that back to the 50% treatment. And the Land Trust Alliance is working to do that, but we just don't know. Okay, so the income and estate tax benefits to the purchaser. Well, the income tax benefits depend on this person's adjusted gross income. So we could go to the next slide, and we've got a contribution worth $700,000, So if this person made $234,000, he could deduct $117,000, and then he could do that again until it added up to $700,000, and that would be the end. So the value to that as a deduction depends on his tax rate, but this person would probably be, I guess, at about 35 or 40%. So the value of that would be about $350,000, very roughly. Now for estate tax, again, that's going to depend on what the estate tax treatment is at the time of his death and how large his taxable estate is. But if he died the next day, before the conservation easement, this property would be valued in his estate at $2 million. And after his death, it would be valued at $1.3 million. So right now, I believe there's a $5 million limit. You can pass on $5 million of assets without paying estate taxes. This may not save him any money at all in his estate taxes if this is his only asset, but if his assets are more than $5 million, there will be a tax savings there. Okay, William asks, does the landowner receive any government help or benefits regarding management of the property, like feral hog control or native species population? I am not aware of any program right now that automatically signs up a landowner who does a conservation easement for government programs. If you do an NRCS conservation easement, you know, I think that opens the communication door and maybe the eligibility. I would say it definitely improves your odds to participate in a program because all the government entities want to spend their money on property that they feel like the investment is going to remain in place long term. And if they do a project on property and then the landowner sells it to a subdivision builder 5 years later, then their investment has been lost. So I think it would benefit you in trying to get those programs, but it doesn't automatically make you eligible for any of that. Okay, in the state of Texas, how many conservation easements currently exist that are not in perpetuity? That's a great question, Sherry. I don't know off the top of my head, but I would guess maybe certainly less than 200. I would say maybe 10% of the conservation easements in the state. And the Texas Land Trust Council has a inventory of how many conservation easements there are in the state, where they are, which ecoregion. So if you're interested in learning more about what has happened in the state, you can take a look at that. And Mike's asking, on the slide showing the 117 per year, the total added up to 3.4 or more. Okay, yeah. So that Mike's putting this slide, which has a $700,000 figure together with this slide, and the two examples are not really the same landowner. So that's a good point, Mike. Your deduction would never exceed the value of the conservation easement. So for this math to work, this person would have had to give a conservation easement which was valued at least $3.744 million, which would most likely require him to have a piece of property worth in excess of $7 million. So this is a pretty valuable conservation easement. But the tax deduction the value of the tax deduction will never add up to the value of the diminution in value established by your appraiser. So you will not ever make money doing this. You should only do this if you have a real personal desire to see the property protected in perpetuity and kept intact and not subdivided, because the the tax deduction won't make you whole. You may be made whole if you have an opportunity to sell a conservation easement and be paid fair market value. But those landowners are, you know, the lucky ones right now. Most people are donating, and they're getting some benefit from this income tax deduction, but for them, the estate tax is the primary driver and the primary benefit for their family.
Okay, we had a few more questions, Allison, that came in through the question and answer panel and some other ways.
Okay.
I'll read those out to you first. Just, can different trusts exchange conservation easements?
Okay, the conservation easement is a right which can be transferred to other qualified holders, meaning land trusts or governmental agencies. And that term, how that works is negotiated with the landowner. Many land trusts will say that if they are going to transfer the conservation easement, that they will work with the landowner to select a qualified holder that's acceptable to them. You have less ability to negotiate that if you sell a conservation easement. Like the city of San Antonio won't agree to work with the landowner because they have, you know, they'll probably have hundreds of landowners. And if they transfer their conservation easements in the future, it will probably be pretty much en masse to another agency. But it is a transferable interest.
Okay. The next asks, how much stewardship donation is generally asked or required from the landowner/donor?
Well, a land trust which is following proper operating practices will evaluate how much staff time it will cost them to go out and monitor the property every year. So there can be economies of scale if you work with a land trust that already has holdings in that area. We find from our calculations, the size of the property certainly matters, but it's not like a small piece and a large piece. There's not a direct correlation between the price. A lot of it is travel time. So to answer your question directly, I customarily see stewardship requests between $20,000 and $50,000. And most organizations will view that as a charitable contribution, which is, again, deductible.
Okay, and I think that goes into the next question. What would be the total estimated charge to complete a conservation easement on a 700-acre wildlife property?
Well, let me try and run through the numbers for you. I would expect that you would pay maybe, a stewardship endowment in that range. That you should expect to spend probably about $10,000 on an attorney and about $6,000 on a baseline. If there are complicated minerals, you would need a geologist remoteness letter, which would typically cost about between $2,000 and $4,000. And the appraisal would typically cost between about $3,000 and $7,000. Those are the primary costs.
Okay, and then one last one, we have, what about co-tenants? If I own 50%, my sister owns 50%, will you take a conservation easement from me alone?
I think that's unlikely that a land trust would do that. I think both the co-tenants would need to participate.
Okay. Looks like we are getting close on time. Got a few things. If people have any more questions to post up, please feel free to do so right now. On the chat window, I just posted up a link. If you're interested in going back through this webinar, kind of watching it again, getting some more info from it, you can go to the link on the TWA webpage and see this and all of our other recorded webinars. And so it will be posted probably middle of next week, give or take. The next webinar we're going to have is on March 20th. It's going to be on invasive grasses, and it's presented by Forrest Smith with South Texas Natives. So going back to the chat window, I don't see any more questions coming in. Allison, I really appreciate it. That was a lot of info to take in, but you covered it extremely well.
I'm really glad. It was a pleasure to present, and I have my contact information here. If you'd like to follow up with me, if you have other questions, or if you're interested in learning more, we are a resource for you, so feel free to contact